Hi friends from around the world. This is a new series on patents. Now, for whom is this series? Well, like all the business channel here, the business and IP channel, it is for people, small businesses from around the world, not precisely from Europe. They have the information on a daily information. What is the IP system? They soak it up on a daily basis. So from around the world, IP students from around the world, and IP lawyers from around the world, because I want you from around the world, be able to talk to EU patent lawyers on an informed way, to put them the right questions, or to put the IP lawyer of your home jurisdiction, which will then be in contact with the European patent lawyer, to have an informed discussion with him, and not soak up what he tells you, and without any critical thought to have wasted about it. So it must be that you have some basic information, right? So it is for all you from around the world in the country where you are. I don't know whether it is Thailand or Australia or Peru. You are welcome here, and you will get it. You will get it all, because it explained in a way that that lawyers without much previous knowledge on the EU system can understand it, and it is presented you in a structured way. So not here a bit and there a bit and you don't know how to put them together. No, it is in a didactic way, and you can build one piece onto the other, and at the end you get an overall picture which gives you a quite substantial view on what is happening in Europe. Sounds good for you? Well, let's get started. What about one thing I wanted to tell you. You think patents is something very, very complicated. These are the business owners which think of that. I would say rather the contrary, because the patent, that is about invention, that is technical, right? And it is, in fact, the patent lawyers. They are called patent lawyers, and you think, well, they are lawyers. They are in reality engineers. They are chemists. They have studied chemistry, or they are biologists, or they are IT engineers, software engineers, and so on. And why is that? Well, it is about innovation here, right? And the innovation, the lawyers, they don't have understanding on what is the technical function, what is the mechanic which is involved in whatever machine it is. So they cannot explain this to whom? To the examiner. And who is the examiner? The examiner is, again, not a lawyer. No, he is another engineer, another people from chemistry, biology, or from mathematics, physics, or whatever. So they speak the technical to a technical. And the appeal, same thing. And even in the courts, you may have a technical engineer who has to solve precisely the technical issues for the judges, which are then lawyers. So my point here is, you may be a business owner and you may have studied economics, but you may also be an engineer. And if you are an engineer, and there are a lot of CEOs or startups who are being steered by engineers, they understand immediately on what it is, and they don't need to have a big discussion on laws. They will understand probably if you go through this video, you have the basics, and you can precisely make a good assessment of what is the technical issue. So the business owner are even more qualified here in the patents in order to take this under control than in trademarks and designs. And why is that for trademarks and designs? Well, these are lawyers. You deal with examiners are lawyers. And the appeal appeal guys, they are lawyers, and the judges afterwards, well, they are lawyers. And the lawyers you deal with, the trademark lawyers, the design lawyers, what are they? They are lawyers, again. So this is a different environment here, and even so, the patent seems more frightening you, as it is more complicated. It is just the contrary. You should understand how to deal with it. So it is also and mainly for you, the business owner. And I give you another reason why patent is important for you. Patents are one of the most valuable IP rights out there. And they have a big function and a big value just right from the beginning. Why is that? Well, the trademark, trademark is new, trademark newly registered. You need to build up the trust with the consumer in order to build a goodwill, so a value around it. The more consumer they know your trademark, and the more consumer appreciate your trademark, the more value it gets. But this will not get overnight, right? You need to make advertisements, and people, they try out your product, and they talk to other consumers, and then over 5, 6, 10 years, it becomes a valuable asset on your balance sheet as intangible. Now, the patent, that has it right from the beginning. So it is about the technical function. It is not about the trust of the consumers. It is the technical function which is able to produce something which afterwards then the product can be exploited by the consumer. But it is valuable from the first moment, and probably it is valuable from the beginning more than at the end. Because at the end, the patent, has a validity, and well, all to say that this is an important series for business owner to have a closer look at, and for IP students and from IP lawyers to be informed about it in order to make informed conversations with your clients or with peer European IP, patent lawyers. So let us go to from the beginning. The patent. What is exactly a patent? A patent is something new, a technical invention which is new, which is different from the prior state of art, from the prior art. This is the term you will hear a lot of with regard to patent. So it is something new and has industrial application. So it can be part of a machinery which then functions in a way that it produces, so to say, something more, something better, something quicker, something more smarter, or whatever it is. So this is a patent. Completely different from design, right? From trademarks or geographical indication we have seen before in other video series. So it is something different, something technical, right? Now, with regard to patents, we have again the territoriality issue, meaning that you can protect your IP right, the patent, according to the territory you're interested in. Well, you cannot also make a patent application in other territories, but you would not do it, because why would you do it? So for the territory which is, so to say, your market, or from where you may find a lot of competition you want to avoid. Patent has normally what would be a 20-year duration. There are people out there which say, well, the patent does not benefit really the society. It goes backwards because it gives a priority to the patent owner. He can exploit this as a monopoly for 20 years. So the society will not benefit from it as a whole, right? They will not benefit from it for 20 years. Well, I think there are others. They say no. The patent is only the 20 years of monopoly is only just reward for what is the upfront and risky investment in research and development. So if you don't have this monopoly afterwards, so why would you in the first place get into this risky investment, upfront investment into research and development? So you have 20 years of monopoly. Now coming to Europe. You know that Europe has 27 countries. The UK has left, so 27 countries are in the EU. And I mentioned territoriality. What does it mean? You have to go country by country in order to get your patent application through and patent registration. With that, the monopoly starts for the following 20 years. So that is a heavy issue, because with a trademark, what you need to present is very straightforward. You have the representation of the trademark, right? You have the goods and services. For the designs, you have the goods and the representation of the design, and that is pretty much everything you need to present. Well, the company and payment, the fee, etc. So there are other requirements, but there's not much more. Whereas for the patents, you have to present a lot of documentation. You have to explain what is the functionality, what is the prior art, what is different from prior art, what is it about, and why it is different from everything else and on the market. And you know, that is quite different, and you have to do it with a lot of explanations, as you can imagine. So again, we come back to the 23 languages. You know this in the meantime from Europe, and you are with many IP, so patent lawyers involved in order to make the filings, to have translated into the 23 languages. And you have to wait and give explanations to the examiner who wants to know this, and he asks that, and so, and you go back and forth. So that is a problem, and the total cost is about 40 to 50,000 euros. So it is a heavy issue for the startups, I would say, or small businesses. And what they do often is, well, I do not go to all of these countries, but I go only to, you know, what are the important countries. What is, I don't know, Germany, Italy, France, and I don't know what country else, Scandinavian countries perhaps, and would leave the rest out in order to save some money. That would be a possibility, and that possibility is taken care of by many from the outside world, so to say, from non-European companies. But that would mean you have a gap, you have weaknesses in your patent protection, and that may come with some downward possibilities or possibilities to put in from your competition and weaken your position on the market. Now let's come to, so this is the situation, right? And I told you about the single market a time ago from the EU, and the single market, they thought about what should we do in order to improve that situation. They came up in 1994 already with the trademark, EU trademark, but just before a patent was more important, it was also discussed to have something being done in favor of the European businesses, or for the businesses around the world, for the patent side. And discussion goes within the EU, and then at a certain moment there came the European Patent Convention, EPC, which has been in 73 already has been adopted, you know, within now in the European and the situation until now. The European patent is a well-established institution, a well-established possibility for businesses to get into the patent. But the European patent is only, so to say, a halfway solution for what would be the best solution for Europe. And it is more or less the what you have to pay for, that is still, again, more or less the amount. So on the efficiency side, we have a big step forward with regard to filing, but the rest is still on the backward. So what is exactly the European patent? European Patent Convention has been adopted by member states, part of the member states, EU member states, right? And there are other states, third countries, so to say, involved, like Turkey and others. And there are in total 37, I suppose, 37 contractuary states within the European Patent Convention. So it is not an EU institution. The EPO, which is the managing agency, the European Patent Office in Munich, Germany, is the managing agency for the European patent, but it is not an EU agency. It is an intergovernmental, so to say, agency or managing agency for the EPO contracting states. Meaning that you can file through the EPO easily. There's only one language in the beginning you can file with. You have to present translations into 2 other languages. So the languages, the official languages of the EPO are 3, which is English, French, and German. And you can, so to say, in English, easily file an EPO application. And then it is processed within the EPO as a patent filing, so to say. And at the end, you get a patent grant from the EPO. But what is that patent grant? That is nothing more than a summary, so to say, a positive opinion from the EPO, but you don't have really a patent which can be enforced at that moment as a rightful patent, cannot be treated as a rightful patent registration. Because this was so to say, the European phase, but then you have to enter into the national phase. And the national phase is that the European Patent Office, they put the file, the grant file, so the application file, to the national offices in the territories you have to designate to. Meaning that at a certain moment, once the patent is being granted by the EPO, you have to designate the territories in which you want to have protection. And then the national phase will give you that protection through the processing of the national agency, patent agency, so the responsible agency for that country. And there are fees to be paid to the European Patent Office and fees to be paid to the national offices. So at the end, it is better for filing, but it is not necessarily something which gives you at the end a different result. No, it gives you the same result. The same result in the sense it gives you a national patent, not an EU patent, but a national patent. So a bundle of national patents depending on the designated countries you have chosen in order to get protection for that territory. So again, 40 to 50,000 euros. It depends also on the countries you choose. The less countries you choose, the less money you have to pay. But for the EU, if you want to have the EU, the comparable cost is more or less 40 to 50,000 euros. And the last word is on the international, the WIPO, the Patent Cooperation Treaty, where you can file through WIPO and to even more countries, but it is more or less the same. So you get a bundle of those countries, patent protection in those countries you have designated. The filing is what it is being made easier for you. So this is the first video on the patents in Europe, so to say. The next this is the actual situation, right? But the next, I will go a glimpse into the future. I will not explain the unitary patent, but you will get to know it. Thank you for tuning in.